This is Michael Popok, Legal AF. It's official. Donald Trump's lawyers have told the court system that Donald Trump does not have enough money to put up the required cash bond to stop the enforcement of the New York Attorney General's over $500 million judgment. And if he doesn't have a bond in place or a stay by the appellate court, hold that thought, that's what he's trying for now, then starting now, Letitia James and the people of the state of New York can take that judgment and start going against Donald Trump's assets, liquidating his bank accounts, liquidating his property, liquidating his real estate, his cars, his boats, his planes, his furniture, his jewelry, you name it. And Donald Trump doesn't want that to happen, but he wants to try to stop it on the cheap. Here's how it works at an appeal. If you got enough money for the bond plus 120%, so 120% of the amount of your judgment needs to be posted. Either a bonding company needs to do it, and they're going to require an exorbitant amount of assets to be pledged by Donald Trump and cash on hand, either by what's called a letter of credit or cash in the bank to give him a $500 million loan, or he's got to put it up in cash. And Donald Trump has now told the court system, and therefore us, that he has to, quote, raise capital and or raise the money to get the bond. So what he's arguing is he's got 100 million of it, and he wants to be able to be let off the hook for the posting of the other 400 million. You can't just spare $400 million, appellate court. So because the law requires, and the law only gives a mandatory stay of an enforcement proceeding on appeal if a bond sufficient to protect and to securitize the judgment is put up first. Short of that, you got to go to an appellate judge or an appellate panel and argue that you shouldn't have to put up the full amount. That's what Donald Trump is doing. But by doing so, he has to concede that he doesn't have the money. And the New York Attorney General, on behalf of the people of the state of New York, is reminding whoever is assigned to this, because the way it works on appellate applications is your first line of defense, if you're a party like Donald Trump, is to file an emergency application in order to show cause with the appellate court, the clerk that assigns it to one judge, one duty justice, if you will, who's responsible for making the decision pending the results of the full substantive panel, which is usually 6 justices of the Appellate Division First Department, which is the Manhattan Appellate Court that sits over Judge Engoron, who was the trial judge who entered the judgment a couple of weeks ago against Donald Trump for persistent fraud in the operation of his business. So they got to hope that they're going to get an emergency duty judge to at least temporarily stay the enforcement and execution of the judgment against Donald Trump's property, or he is going to lose assets. And I'm talking about like now. Now, is there a chance that one of the justices reading the papers will find that Donald Trump made meritorious arguments for the ultimate reversal of Judge Engoron's $450 million judgment? It's possible. Anything's possible. You know, they already got an emergency judge at one time to stop the case for about 4 days, but that same judge got reversed not once but twice by the full merits panel. So once the full merits panel is in place, which would be, let's say, a week later, it's unlikely that Donald Trump's going to be able to overturn the judgment amount or the bond amount. And in order to do it, he's got to pay to play. He's got to put up enough of the bond amount, enough of the judgment amount, 120% of it, in order to even get heard in appellate court. You know, so somebody wrote, and one of my colleagues, Ben Meiselas, wrote it to us in a chain as we were preparing these hot takes. Somebody wrote on social media, it would be, if you don't post the bond while you're appealing, it's the equivalent of appealing your death penalty sentence while the lethal injection is in your arm. Not going to work. So he's got to get relief, Donald Trump. And the problem is he's now told the world that he's a failed business person. We thought, based on reporting, that Donald Trump had between $350 and $400 million in the bank, which is still short. It's still short of the over $500 million that he has to put up for this bond. I haven't even talked about the $83.5 million bond plus 20% that Donald Trump has to put up in the E. Jean Carroll case just up the street at the same time. So he's scrambling to find $600 million. He's just told the world he only has $100 million. He's $500 million short. That's a big short for those that don't follow the law. Now, I did another hot take that'll be going up soon about what he's hoping for, right? What Donald Trump is hoping for. He's hoping to get to late March. And in late March, he may have access to up to $4 billion in money from his Truth Social going public, because he owns like 79 million shares at $42 a share. He's got a lot of money. It's tied up for 6 months unless he gets a change in the rules and gets access to that money for a loan. But right now, which is what matters, because he could lose a building, a property, a house, a boat, a yacht, Melania's clothing. Who knows if this judgment is not stayed? And the Attorney General has reminded whoever gets assigned to this case, and we'll know it later today, that this should not be done, that no part of the judgment, not the money part, not the part banning him from getting loans. See, I love this part. This is Letitia James cutting off access to capital markets by Donald Trump. He says he has to raise the capital. She doesn't want him to raise the capital from New York banks. So she said the other part of this that should not be stayed pending the full appeal is the ban that the judge imposed on him right now, Donald Trump taking loans out with New York banks. So she's no dummy. She knows that he might try to do that. So she says that's another aspect. Don't let him go to banks in New York either. At first, she reminds whoever's going to get assigned this that as a judgment creditor, the people of the state of New York have the right to have enough security in case there's a problem with collection down the road. And what would be the problem with collection? Donald Trump's already admitted that he's tried to reform companies in Florida, which he just admitted to the New York judge, to try to get out from under the monitor. And the monitor already reported that a month or so ago, Donald Trump moved $40 million without her knowledge out of the bank accounts that she was supposed to be responsible for supervising. So New York Attorney General argued he can't be trusted. I need the security of the bond because this guy's going to be busy dissipating, liquidating, and hiding assets. As she said on page 3, contrary to defendant's argument, there is substantial risk that defendants will attempt to evade enforcement of the judgment or make enforcement more difficult. Following appeal, even with the independent monitor that they now tout, defendants have already, during this action, surreptitiously transferred $40 million from their accounts without disclosing the transfer to the monitor. Then, after the court issued its February order, defendants announced for the first time that various Trump Organization entities operating in New York are now in Florida, right? So they have to do something to ensure that the defendants do not dissipate their assets. She reminds whoever's going to get this, and again, it'll be assigned later today, she reminds whoever gets it that they have the right now as the judgment creditor in a case to have full security and protection. As to the other aspects of the order, she says the independent monitor, of course, needs to remain in place. There should be no stay related to the independent monitor being placed. And here's my favorite on page 4. Loan bar. Last, the court should deny an interim stay of the enforcement of the Supreme Court's order barring Mr. Trump and Trump Organization from applying for loans for certain New York financial institutions. As an initial matter, contrary to defendants' contentions, the Office of Attorney General does not interpret such a bar to apply to sureties that could provide defendants an appeal bond. In other words, if he can go find a surety, a bondsman, a bail bondsman to put up the money, great, but not banks, because that would be violative of Judge Engoron's decision. As she said on page 4, the court made over 60 pages of detailed factual findings and credibility determinations pertaining to the defendant's financial misconduct, and the judgment in that respect should not be lightly disturbed in this preliminary posture. Even without the benefit of additional loans, the Trump Organization may continue to operate in New York, and defendants may continue to earn profits from the operation of the Trump Organization. A bar on new loans appropriately maintains the current state of defendants' business while protecting against future fraud. What she doesn't want him to do is go borrow the $500 million. Just saying, Letitia James, we know that's what you're thinking. And the other thing that people aren't saying, that's something that she's not saying out loud. The thing that Donald Trump's not saying out loud is he's trying to get to March 22nd when a SPAC, a special purpose acquisition company, goes public along with Trump's Truth Social. And he could get up to $4 billion if he could convince the sponsor and the shareholders to let him access the money now instead of in 6 months as required, or take loans out against it. Otherwise, he's going to have to make transfers to family members and then borrow money from them. But Trump doesn't want to act like he needs that money. So he's not mentioning that money because he doesn't want Letitia James going after that money as part of her judgment. This is the quandary that Donald Trump is in that we're watching play out in real time. The next step will be another hot take once we determine who is the judge, the justice from the New York Appellate Division, First Department, assigned to this emergency stay application. Then there'll be a hearing and we'll get reporting on the hearing, and then we'll get back on the air and tell you what happened, whether it was stayed or not. What Donald Trump is looking for, again, is to have an emergency duty judge or justice of the Appellate Division, First Department, for a short amount of time, maybe a week, stay the enforcement of the judgment so he doesn't lose assets in the meantime as Letitia James goes after his property to collect on her $500 million judgment in favor of the people of the state of New York. He wants to post a $100 million bond, but in order to do that, he's got to convince an emergency justice and then other justices that is appropriate. So we'll follow it. We'll report back. MeidasTouch, Legal AF, Wednesdays and Saturdays at 8 p.m. Eastern time, only on this YouTube channel, and then on audio podcast platforms of your choice. So until my next hot take, till my next Legal AF, this is Michael Popok reporting.
Hey, Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.